So I think that's good enough. Well, people will still be logging in here, but as we get going, I'd like to go ahead and get started. So first, just wanted to welcome everybody to this iteration, this presentation of the interactive dialogue series that we've had here at Dorsey and Whitney for about 6 or 7 years, where we take a topic and instead of having a massive 75 slides in the internet over an hour, we try and keep it a more reasonable number of slides, high level, and then talk about some of the practical implications of things that are happening. And it's really been terrific and a great way to get information to our clients quickly and in a way that's very kind of pragmatic and directed at the kinds of things that they're wanting to talk about. So in that regard, today I'm delighted to present with two of my colleagues from our Salt Lake City office who will introduce themselves in just a moment on the really interesting new topic of California's sweeping new climate and carbon disclosure laws that have really significantly broad impact, of course, to California companies, but then also to others, as you'll learn about more during this presentation. I was personally fascinated to kind of think about, okay, if I were a company of varying sizes, how would I be looking at the climate disclosure requirements that are now being imposed on me in California, given that it's such a significant market and the importance of it to how we operate. Typically, the programs, I'm one of the co-chairs of the food, beverage, and agribusiness industry group. Typically, the programs that I present on are focused on that, but this one's going to be of more general application. So a couple of housekeeping things. First of all, the materials and information were sent to you in an email format that was sent from DorseyU@dorsey.com. So please look at that. We will be accepting questions and answers, and also you'll see a chat pane. So please don't hesitate to ask us questions during the program. I'll be monitoring the chat pane, and if there's any question that you'd like to keep confidential as to your name or the company, then please say so. I do try to kind of anonymize the questions, but we would like to address any questions you have throughout the program. We also have activated the question and answer pane, so that will happen towards the end, and people can ask their direct questions. Will request CLE and expect it from the jurisdictions that are listed below. To obtain that CLE, you should send information to the attendance at dorsey.com. You'll be receiving an attendance form, and so all the information's there on that form. Very simple and straightforward. All right, so getting on with the program, Megan, can you tell us a little bit about yourself and your background?
Sure. So as Mike mentioned, I'm a partner in our Salt Lake City office, and I am the chair of the Regulatory Affairs Practice Group that spans several different offices. My background is primarily in environmental and natural resources law, everything from environmental compliance to kind of large projects development on public lands in the mining space, industrial space, and others, manufacturing as well. And so this particular topic does have some applicability to companies that we assist and have been getting some questions about it. And so we thought it might be helpful to give this presentation. And as you'll see, there's maybe more questions at the end of the day than answers, but we'll try to at least let you know where we think this is headed, and happy to field questions as they come up.
Megan, it seems like every time I talk to you, you're on the phone driving to some client site or another. And so I take it you work in a multitude of different jurisdictions. Is that right?
Yes, that's right. So our group largely covers everything in the Intermountain West as well as across the Midwest. Me personally, I'm licensed in Utah as well as Wyoming. We have an office in California, and we've reached out to our California practitioners to ask them their thoughts about these new laws as well. So yeah, we work across state lines in a lot of different jurisdictions, helping clients with compliance.
Terrific. Kayla?
Hi, yeah, I'm Kayla Race. I am also in Dorsey's Salt Lake City office in our Environmental Regulatory Affairs Practice Group. So I help clients in a variety of industries, natural resources, energy, and all kinds of industries with environmental compliance needs and other kind of environmental and energy and natural resources transactional needs. And so that's my experience as a lawyer. And before I became a lawyer, I actually worked on climate policy in California for quite a number of years. So coming full circle here now.
Welcome home.
Yeah.
To climate policy in California for sure.
Yeah.
Terrific. So we have a good agenda. We're going to be talking about the 3 different statutes that all kind of went into play in the end of last year. And Kayla, can you kind of briefly tell us at a high level what the 3 statutes were?
Yeah, so at a super high level, the first bill on our list here, SB 253, requires companies to disclose their direct and indirect greenhouse gas emissions. And the second bill requires companies to disclose what kind of financial risks they're facing as a result of climate change impacts to their operations. And then the third bill covers actually what I think of as 2 different topics. It contains disclosure requirements if you're selling or marketing voluntary carbon offsets, and also regardless of offsets, if you are making certain kinds of sustainability claims related to carbon neutrality and net emissions, there's disclosures for that. And we'll get into more detail on exactly who's required to make these disclosures and a little bit more detail on what they entail and when.
So not to steal your thunder, but I live in Washington State. I'm also licensed in California, work a lot there as well. But for my clients in Washington State, is this something that would apply to them or other jurisdictions as well?
Yeah, if you all of these, the first 2 laws apply if you meet a certain revenue threshold and you do business in California. So even if you're formed in another state, if you're doing business in California, then these laws might apply to you directly. They also might apply indirectly as well, because maybe one of your clients or one of your suppliers is directly affected, and they might start coming and asking you for information so that they can meet their compliance obligations. And then the third law is similar if you're operating in California and making these kinds of making these sales or marketing claims in California, even if you're formed in another state, then this might apply.
I'm kind of reminded of some of the ESG requirements where many companies that I work with were, questioning, why am I getting asked all these questions, from the banks and other places where, I'm not registered with the SEC or whatnot, but nonetheless, it seems like there are ways that these laws can apply to you, at least as far as information and tracking for the people that you're doing business with. So is that an accurate statement?
Yeah, I think that's accurate. And one point of distinction with some of the SEC's proposals is that these laws don't care if you're public or private. SEC only applies to public companies, so they're somewhat broader than the SEC's law or proposed rule.
And Mike, I'll just jump in and add, I see some questions in the chat even already about, what does it mean to do business in California? What about parent companies that have subsidiaries and vice versa? And I think that, unfortunately, there is no definition in these laws, which, can happen with statutes, that there's not a good explanation of applicability, and further regulations are required to flesh that out. And so I think that's one of the biggest issues that the California legislature and the implementing agencies are going to face with respect to these laws, is to determine what it means to do business in California. I think that with our global market economy, that becomes very tricky. Are there online sales? Does that count? How widely applicable are these laws going to be? And do you have a federalism problem where states are imposing their laws on other states? So I think a lot of that is yet to be seen. Unfortunately, we don't have a lot of clarity, as these laws just went into place and regulations are being promulgated and proposed or considered as we speak. They haven't even been promulgated yet. So I think we'll have to wait and see kind of how they narrow that and whether they narrow that.
We're kind of jumping to the last bullet point in a way, and I'm reminded really of other major sea change laws like Dodd-Frank, Sarbanes-Oxley, other statutes that really kind of were really brand new, and that's why I commend the people listening in, because really getting information now, it helps you affect what the regulations could be by giving comments and the like, and then also, frankly, preparing yourself for the kind of information that you'll be asked for by various different kinds of people. So we have a format which I really, really appreciate, which is a who, what, where, when model. I feel a little bit like I'm a reporter. Who, what, when, where, why, how, and then for lawyers, were there any witnesses to all this? And do you have any documents? But in any event, how'd you come up with that model? I love it.
I think it's from my work before law school, where we're working on policy, and sometimes we'd send out press releases, or whether it be on policy matters or for events, and that was just an easy way for people to, we're all busy, right? We just want to get straight to the point and be able to skim for the information that you care about.
Absolutely. So we'll start by talking about the first statute, and as we do, just a note for the people who are participating that we're going to do the presentation on a somewhat high level for each of the statutes, but we also have a very robust appendix for additional information and the like, which we won't necessarily be talking about, but I wanted to recommend it to you. So could one of you talk first about SB 253 and who it applies to?
Yeah, sure. I was going to cover this one. Yeah, so SB 253 applies if you're a U.S. company, meaning that you're formed in any of the states within the U.S. or D.C. or under the laws of Congress, and your total annual revenue is over $1 billion, and you do business in California. And as Megan mentioned, doing business in California is not just defined in this particular bill. It is defined in another area of California statutes in the tax code, and they say that it is actively engaging in any transaction for the purpose of financial or pecuniary gain or profit. So that's pretty broad. So if this bill gets interpreted similarly, it could be quite broad if you are hitting that annual revenue requirement, and that's just your entity's annual revenue. It's not limited to revenue within California.
Got it. That's a key distinction, I think, because you could be a large company that doesn't do much business in California, but nonetheless be covered based on that definition, right?
Correct. That's the way that it is likely to be interpreted. But also, as Megan mentioned, there will be regulations coming out from the California Air Resources Board on this, or CARB. And so it's possible that some of these kinds of potential ambiguities could get worked out there.
Yeah.
Yeah.
So as we kind of move along, just making sure it's clear, this applies only to U.S. companies, right, that are organized within the laws of the U.S. So if you're a company from Canada, Mexico, Japan, China, et cetera, then you would not be directly covered, right?
Correct. That's the way it's written. Yes.
But the subsidiaries, if you had a U.S. operation entity that was organized as a U.S. company, then that one might be.
Exactly. Yes.
And then do we know yet about subsidiaries generally, like what the definition of a U.S. company is and whether the revenue is in the aggregate or not?
Yeah. So it's if you are a partnership, corporation, limited liability, or other business entity formed under any of the laws of the United States. So that's the definition of my shorthand U.S. company. As for subsidiaries and parent companies, this law actually does not expressly speak about parents and subsidiaries. It just applies if you are hitting that revenue threshold, and if you are doing business in California and you're formed under one of the laws of the states. But so these reports, these annual reports, require you to report your direct and indirect greenhouse gas emissions consistently with what's called the Greenhouse Gas Protocol Standards and Guidance, and which is an NGO, NGO. And their standards do allow for consolidation of reporting between parents and subsidiaries, depending on usually the level of control or the level of ownership. And so it's not clear exactly how that kind of consolidation in the greenhouse gas protocol might mesh with this law's revenue thresholds, and whether there would be kind of consolidation of revenue to trigger the law. These are the kinds of the things that hopefully will get clarified in the regulations.
Yeah, this point I thought was really interesting because to me, it's the kind of thing that would trigger litigation because they're kind of delegating really important coverage questions to non-governmental organizations that aren't really acting under the color of law per se, and also creating really huge ambiguity for businesses trying to figure out, okay, so what is the actual standard? If it's to some other entity, that's a nonprofit or other non-governmental organization, makes things very complicated, I think, and
Yeah.
frankly, cause for litigation.
I agree. The fact that they're kind of deferring to these NGOs does, it limits the opportunity for public input, I think, and that is potentially problematic. But there is also a provision that in a few years from now, California could create a different standard, but that's after 2033. So for the next 9 years, we're looking at following this greenhouse gas protocol, this NGO.
Wild.
Yeah.
I loved the acronym CARB. By the way, I'm always fascinated by these things, and I thought, couldn't they come up with an O and an N, but I couldn't come up with a good one either. So anyway, CARB, it's either carbohydrates or carbon input, who knows? So you mentioned timing, and can you talk a bit to when things will begin to apply to companies?
Yeah, so CARB is supposed to adopt regulations by January 1 of next year, which means that's a tight timeline. And last I checked on their website, they hadn't initiated a rulemaking yet, but that was yesterday, I think. So I don't know if anything has happened this morning, but so they should be making regulations. And then the first reporting deadline is January 2026 for Scope 1 and 2 emissions. So those are your direct and a limited amount of indirect emissions stemming from your electricity purchases. And then starting in 2027 is when Scope 3 emissions will be required to be reported. And Scope 3 emissions are indirect emissions. Basically, I think it's easier to understand in an example. If say you manufactured Cheerios and you buy your wheat that goes into the Cheerios or oats, or and what are the emissions of the farmer who's growing those crops that go into your product? That's what those
None. They promised me there are
indirect
none.
emissions are. What's that?
I said they promised me there are none. I've talked to farmers.
Yeah.
Oh no, we have no emissions, none whatsoever.
Carbon neutral. They're carbon neutral.
Totally. Well, no, because then we'd have to have disclosures under the third statute. So.
Exactly. Yeah.
But and so that kind of begs an obvious question, Kayla, about how does one know what these emissions are? I mean, there's going to have to be a interconnected web of disclosures that, if I'm a bigger company, I'm going to have to find out, my bank, do they have people that drive to fill the ATMs and therefore have carbon emissions relating to, like, who knows how far it would go. I mean, it could be very significant, it seems like.
Yeah, it is, especially with the Scope 3 emissions included. It's hard enough, I think, to measure your own entity's emissions, and then in order to get those indirect, those Scope 3 emissions, there are ways to do it to measure from industry averaging, but you might also need to get information from your suppliers and from your customers in order to accurately report. So you're probably going to need to hire some technical experts to help with that, unless you have a really large team in-house. And along with that, the law requires having these, what they're calling assurance engagements, which is basically just third-party independent verification. So in addition to needing to collect all this information yourself, you need to have someone else looking and meeting certain standards, looking at your data and making sure it's accurate.
You know, one of the things as I was thinking about these scope 3 emissions in particular is that this statute's one clearly that applies to only very, very large companies, over $1 billion in revenue, and US, formed entities, companies. But, if those companies, which I would want to do business with, as a smaller company, are requiring certain information and disclosures, then this is definitely one to watch, even for smaller companies, because of that implicit disclosure requirement kind of coming up over the next several years. Is that a fair assessment?
Yeah, exactly. I think that's why this is a bit of a sleeper, because it sounds like it's only applying to really big companies, but those big companies are probably going to start asking their suppliers for information, regardless of those suppliers' sizes. And some large companies already do that, and some large companies are already tracking their emissions, but not everyone is.
Got it. And you've used the word emissions. Can you just briefly talk about what that phrase is for folks that are not in the regulatory world?
Yeah, so greenhouse gases, I guess, is the first thing to explain. And that's greenhouse gases are carbon dioxide, nitrous oxide, methane, hydrofluorocarbons, and perfluorocarbons, and sulfur hexafluoride are all the kinds of greenhouse gases that there are. But those are the kinds of gases that are causing climate change. And in terms of emissions, greenhouse gas emissions, Scope 1 emissions are what you might think of as your traditional emissions. It's stuff coming out of the tailpipes that your business entity owns, maybe a diesel generator or a gas-powered vehicle. Those are your Scope 1 emissions, or your power plant emissions, or if you're a utility. But your Scope 2 and 3 emissions are direct. Those are emissions that are from directly emitted by other entities, but you have some responsibility for them because you're purchasing products or electricity or what have you from them.
Got it. And Kirk asked an interesting question. That is that the data reporting information will it be in arrears, meaning that, say 2026, are you going to have to report on 2025 data, or is the reporting for 2026, then you would do that at either the end of 26 or 27? Just kind of trying to figure out where the starting line is here.
Yeah, it's supposed to be for the previous reporting year. So if you have to start reporting in 2026, that would mean that you would be reporting on your 2025 emissions.
Got it. And then can you briefly talk about the fees and penalties?
Yeah, so the law doesn't set the specific amount of fees, but CARB in the regulations that they make is going to come up with some kind of annual fee to help pay for the implementation and enforcement of the law. And then the penalties can be pretty hefty. These are administrative penalties that could be imposed by CARB, up to $500,000 in a reporting year, which means that the per violation or per day penalty is likely to be smaller than that, but that's not detailed in the bill. That's going to be detailed in regulations.
Got it. Getting some really interesting chat questions here, some of which we may not have time for, but Chuck comments that companies would potentially be encouraged to create subsidiaries and entities that have less than $1 billion in revenue, in particular, looking at the expenses related to data monitoring and gathering, which is kind of what we talked about, too. So it'll be interesting to see how that plays out as far as what the regulations say. And then there was a question as well about what Scope 3 emissions might be included, because there are different categories apparently of Scope 3 emissions, and do we know yet what that would encompass?
No, I think that's the kind of details that's going to need to be worked out in the regulations.
Well, I think reference to the greenhouse gas protocol would probably be the place to find. I mean, if you're reporting consistently with that, then that's the standard that's set forth in the statute. So I think that's really the only place we have to look, unless and until there are regulations, right?
Got it. And I think that's referenced in the appendices, right?
Yeah, I think I have definitions.
So then we get to what I'm calling the mini SB 253. It's probably an inaccurate description, but Senate Bill 261, called the Climate Related Financial Risks. They really need to work on the names here. We have CCDAA, KKDA, and then now we've got Griffer. Anyway, Megan, what's this one about?
Yeah, so not necessarily a mini 253. It's a pretty large departure, in the sense that rather than reporting on your direct or indirect emissions, this is more inward facing to determine what your climate related financial risks are. So how is climate change impacting your business? Is that something with respect to availability of materials? Is it physical, right? Or do you operate on a coastline? Is your operation at risk for higher tides or rising seas? Is your operation weather dependent? These kinds of climate related financial risks. And I mean, the definition, and I guess I'm jumping ahead to the what. Maybe I'll back up onto the who. So this is applicable to, similarly, U.S. companies, a total annual revenue of over 500 million, as opposed to the billion in Senate Bill 253. Same who does business in California. And then there is an exemption here for entities that are in the business of insurance. And so, I mean, obviously there is a pretty significant climate risk to insurance companies. We're already seeing insurance companies, especially in California, withdraw policies for homes and businesses that are at risk of sea level rise and extreme weather events. And so, these climate-related financial risks and the requirement to post them would not apply to insurance businesses in California.
Got it.
And then I can jump into the what here. So the definition of climate-related financial risk is material risk of harm to immediate and long-term financial outcomes due to physical and transitional risks, including but not limited to risks to corporate operations, provisions of goods and services, supply chains, employee health and safety, capital, financial investments, institutional investments, financial standing of loan recipients and borrowers, shareholder value, consumer demand, financial markets, and economic health. So that pretty much covers the gamut of anything that you could think of that would impact a business.
Got it. And we have a question actually was kind of interesting, that there were some line item vetoes that occurred with regards to some of this, and that included the financing related to enforcement, because and I thought this was really an interesting question, because it seems to me that if I had a company, if I were working in a company of this size, for example, and we're filing a sales tax return in California, which almost by definition would mean we're doing business there. Then I'd start to think, okay, this is something I'm going to be required to disclose, but that's going to be just a mountain of information that's being sent to the regulators, and how would they deal with that? And if they've got no additional revenue, how's that going to work?
Well, so this law, as opposed to 253, which does require the reports to be sent to CARB, this is just a posting on a website. And so this is self implementing, that in that you just determine what your climate related financial risks are, and you post it on your website, and it's there for everyone to see. So in terms of the enforcement budget, they're for CARB to determine whether companies are complying with this and doing it sufficiently. That'll take someone looking at everybody's website and seeing whether they've appropriately disclosed their risks. And this is tricky, right? Because it's very subjective as to what risks there are, and how a company views those risks, and how they report those risks. And so I think this one's going to be, this could lead to a lot of pushback or litigation, as you mentioned before, if CARB comes in and says, hey, you didn't disclose that sea levels are rising, and we think that's a climate-related financial risk to your company, and you didn't report it. And the company says, well, we don't think it's a risk because of X, Y, and Z, or, for whatever reason, there's a disagreement about what the financial risk is. I think that could cause some disagreement with the agencies or implementing authorities.
Yeah, this one to me just screams class action risk. And under California law, PAGA, Private Attorney General Act, risk. Because if it's something that's got to be on the website, and I were someone who filed a lot of these lawsuits, then I would go to a store and look at an item, and then look up their website on my phone, and see if they had this disclosure. And if they didn't, I'd file a lawsuit. And then I'd look at the next item on the shelf, and if that one, is from a bigger company and they didn't disclose, and there's a second lawsuit. And then I'd retire when I was out of the store, because I'd have, made enough on those class actions to be done.
So interestingly,
Am I
though,
too much a scare tactic person, or am I just, once bitten, twice shy with wage cases and Prop 65? And
so both of these laws, it's an administrative penalty, so it's not clear that an individual would have standing to bring a claim for violation of this lawsuit, or these two laws, versus the next law, AB 1305, has civil penalties and a broader array of people who can enforce it.
Got it. So there'll be potential for litigation, but we're not sure yet whether there would be standing. And so it'd be or whether they could do a PAGA claim, and basically be acting as though they were the Attorney General potentially. I think
that's unclear at this point, Mike. And when I was saying litigation, I was thinking more of, if you're the company that has been told you're in violation, the pushback from that, they would challenge and contest the agency determination about being out of compliance. But you raise a good point, and I think that's probably another presentation worth of analysis to determine whether how big of a risk that is.
Yeah, and to some degree we don't know. But part of this goes to an ultimate question I'll be asking, as both of you know, and that is kind of who should be worried about this within the company. And as I think this one particularly, it's kind of a marketing department, and whoever owns the website should really be paying attention and saying, hey, we've got another requirement here. So we have to comply, for example, with Americans with Disabilities Act, and what we disclose. We have terms of service, privacy policies, and the like. And then this is another disclosure requirement if we fit the jurisdictional requirements that we'll have to comply with. So, and then you had, Megan, some items in quotes, and I find those kind of interesting, because there seems to be so much ambiguity. Things like measures adopted to reduce or adapt to climate-related financial risks. So, first of all, that's only financial risk, not other risks, but maybe that's all-encompassing anyway. And then, reduce and adapt. That do we know what depth of disclosure would be required? Is it be like a sustainability report level, or is it a, deep analysis, or do
So
we just
yeah,
not know?
well, no, I think we do have some guidance. So the law requires the reporting on the websites to be consistent with the Task Force on Climate-Related Financial Disclosures, or TCFD, or an equivalent or consistent framework. So this is so when you ask who at the company should be concerned about this, I think it's all the people you mentioned, but also the accounting team, right? The CFO of the company, because these are likely also, to the extent they are a public company, they're probably things that have been reported in their annual reports on financial risk. And then TCFD does, or TFCD does have some standards on, what's material, what kind of disclosures or what kind of reporting is required under that standard. There's also some other equivalent standards, the International Sustainability Standards Board, or ISSB. That's what a lot of our mining companies look to, as well as the TCFD. So I do think there are some standards there, but there's still a lot of flexibility within those standards, and some qualitative decision making by the company to report on what actually is a risk. So there is a framework. That's where these quotes come from, but there's still some ambiguity there.
Yeah, this is why the class action risk would be such a concern if I were a company, because that those ambiguities, of course, are things that get you through to a trial, and you'd be filing your lawsuit based on anybody within the state of California who purchased your product. So, that's a pretty likely substantial number of people, and then claiming that a certain disclosure wasn't significant, didn't meet the requirement, although, like you said, consistent with, those kinds of words are helpful to some degree, because it gives a little bit more latitude to the company to manage, I suppose, right?
Well, and I think the same risk that you're talking about, we've had some presentations in the past about the SEC's proposed rules, and I think Kayla mentioned them early on, that the SEC tried to come out for public companies with, did come out with proposed rules that have not yet been finalized, that required some of the similar risk disclosure in annual financial statements for public companies, and that was one of the bigger concerns of the companies is, who decides whether we've done this properly? And if you have, mistakes or material misstatements with respect to these financial risks in your audited financial statements, that's a pretty big deal for executive clawback. I mean, there's all kinds of issues that arise with that. So it's not just in this context that what you've described is of a concern. That's been in other proposals as well.
Yeah, fascinating. Don't touch that dial, right? We're going to learn a lot more over the coming months. All right. So the next one is AB, which stands for Assembly Bill, not Senate Bill, the SB. It's Assembly Bill 1305, called the Voluntary Carbon Offsets and Carbon Neutral Marketing, or VCOCNBM, VOCAMUM. Anyway, and Kayla, you'd said to me when we were prepping that this statute didn't get quite as much press as the other ones, and I'm curious what you think that is coming from. Why wouldn't it have gotten quite as much notoriety, I guess, as the first two?
I actually have no idea why it's gotten less press than the other two. They all passed right around the same time. Maybe, I don't know if fewer entities are purchasing and selling voluntary carbon offsets and making carbon neutrality claims, but I would actually think this law applies more broadly because there's no revenue threshold trigger.
No size of the company.
Yeah, it's a mystery to me so far as to why this is not getting as much attention.
So, so the first is that it applies to, and there's some other things too, but I want to start with the first one. It applies to any business entity that markets or sells voluntary carbon offsets. So lots of words packed into here, but so
Yeah,
starting with business entity, it could be anything, right? It could be, we're not talking about just U.S. companies on this one, correct?
correct. Yeah, it's just any business entity, but it does have to be marketing or selling the voluntary carbon offsets within California.
Got it.
And it's a voluntary carbon offset is defined in the bill, and that's it's any product sold or marketed in California that claims to be a greenhouse gas emissions offset or a voluntary emission reduction or a retail offset or any like term that connotes that the product represents or corresponds to a reduction in the amount of greenhouse gases in the atmosphere or prevents greenhouse gases in the atmosphere. But voluntary is key because this does not include products that represent or correspond to legal or regulatorily mandated products for either reducing greenhouse gases or preventing greenhouse gases.
So I'm going to ask a couple of specific follow-up questions. First of all, this is to the companies that are selling the offset, not necessarily the ones who are buying the offset, right?
This number one, we'll get into number two of the who.
Okay.
Yeah.
But got it. So I'm correct so far, but we had
Yeah.
only the first part of the equation.
Yeah.
And then can you give just a practical example of this for people who are not in the carbon offset market? Like
Of
what
what
would be a voluntary carbon offset and what kind of company would sell it and that kind of thing?
It might be a company that, to go back to the farming example, they own farms and they change their farming practices to be no-till, or they switch out their diesel tractors to be electric powered or use gas that is less carbon intense. And so they might be able to measure and measure those emissions reduced from those practices and sell the offsets through a registry. There's also entities that manage forests and protect those forests that might have otherwise been under threat, and sell the carbon saved by the forests as offsets as well. And companies that might buy those things are companies that just have voluntary sustainability goals. And maybe they've done already everything that they can already to directly reduce their own emissions, but they need something else to get them to meet their total goals.
So, for example, I've seen many companies make personal or corporate declarations that will be carbon neutral by 2050 or 2035 or some number, and in some cases I've looked at the companies and I've thought, okay, how's that going to work? You're an airline or you're in some other thing where we know that you're generating a certain amount of carbon. It's just part of the operating business. And so that would mean you have to have some that are negative, perhaps. But what you're describing is an exchange where I could actually take, if there's somebody who's a carbon producer that drops their carbon, then that drop is something that is marketable and can be purchased by somebody else to offset the carbon that they're using, right?
Exactly. Yeah.
Got it. Okay. So that's interesting, but not the big news. So, or at least the big risk, I think. The big one is if you make certain claims, and so can you talk about this second prong?
Yeah. Yeah. So if you're operating in California and you make claims in California that you or one of your affiliates or one of your products is carbon neutral, or your net zero emissions, or you do not add greenhouse gases to the climate, or you've made significant reductions in greenhouse gases, that all triggers these disclosure laws. And so I think we could just advance to the what to get into what the disclosures are for each of these
Got it.
entities. Yeah. Yeah. So maybe since I was just talking about the sustainability claims, I'll go to that and then go back to the carbon offsets. But yeah, so if you're making one of those kinds of sustainability claims, your carbon neutral, net zero emissions, you have to disclose on your website, so not to any particular agency, but basically how you're achieving those claims, how, if at all, the claim was determined to be accurate and accomplished, what kind of progress you're making towards achieving that goal and how you're doing that. And if you are using voluntary carbon offsets to meet those goals, you have to disclose that. And you also have to disclose whether you've had any kind of independent third-party verification of those claims. And then if you're that first kind of entity, you're selling or marketing the voluntary carbon offsets, you have to disclose a whole bunch of details about what offset projects you're selling or you're using to sell the offset. And that includes what protocol you're using to measure emissions, the location, the timeline of the project, how long it's going to last. There's a list of 10 things in the statute. And then you also have to disclose how you're being held accountable for making sure that your offset project does what it says it's going to do, and what happens if it doesn't, and also data on how you actually calculated the reductions or removals from that offset project, so that someone else could come in and verify. So it's a lot of data that needs to be disclosed.
A lot of data
on your website.
On this one, on number one, I would imagine that you kind of know whether you're in that market, right? You know that you're selling, a carbon offset within California, but the sustainability one, it strikes me as more of a trap for the unwary, because if we go back, I'd just like to kind of go back to the previous slide, and that you're making a claim in California, so that means that's some ambiguity there. Obviously, if you have something on your packaging, then you're making the claim, but it also could be on your website and available to California consumers, which of course all websites are. And then a couple of other kind of observations, I guess. First is that it's the current state that you're making a claim about. So if you say we aspire to have net zero emissions, or we plan on having net zero emissions at a certain time, then that's something that would fall outside, I think, the definition, because it's rather whether you're advertising that you have achieved them, right?
I think so. But
and
that's
then
something we would want to examine. The precise wording used.
And then likewise, Amy asked actually in the chat pane a question about what does it mean to make significant reductions, right? So is there a definition, or are we waiting for regulations on that one?
I do not believe there is a definition of that one.
So, again, we go back to my friend penalties. So we'll get to that right now. So first is when, and you had listed here, updated annually, unspecified start date.
Yes. So you have to, once the law becomes active, you're supposed to make sure that the data is updated annually. But unlike the other two laws, there's no express effective date of this law. And now California does have a law that's, if any law doesn't have an express effective date, there's a default where it's supposed to be the next January 1 following a 90-day period from the enactment of the statute. So that would be arguably January 1, 2025, because this law was passed in October 15th of this past year.
So that's
but
like
I've also seen some
tomorrow, practically, it feels like, the way 23
exactly
went.
But I had previously seen some legal analysis guessing that it might be January of this year, but that the way that I read the California's default statute, I think there's a good argument that it's next year, and that actually is what the bill sponsor had intended. He's written the letters explaining that, which obviously doesn't have the force of law, but could maybe help in a legal argument if some kind of action were brought.
Mm-hmm. Well, a never dull moment. And so then finally, last but very much not least, the penalty aspect. So you'd mentioned that this is one where you think it's more likely perhaps than some of the others to lead to the potential for individual enforcement actions or the like. Can you talk about both the penalty and also that risk?
Yeah, well, it's a civil penalty, and up to $2,500 a day, max of 500,000. But this expressly says it can be brought by not only the California AG, but by any district attorney, by any county council, or any city attorney in any court of competent jurisdiction. So that seems to be a broader list of entities that can expressly enforce this law.
Yeah, and creates the PAGA risk as well.
Mm-hmm.
So good times. All right, litigation in California, that never happens, but except for regularly. So anyway, all right. Megan, do you have any comments on this statute from your perspective?
Well, I was just looking through some of the comments that have come in, and it sounds like there's a similar French law that we'll certainly take a look at. I wasn't aware of that. And then, there is a question about our claims. If a company makes claims about emission reductions that are possible if someone uses their product, right? So I guess I could see like an electric scooter, right? If you use our electric scooter, you'll save however many GHG emissions, is that a significant reduction, or does it really just apply to the company itself saying, hey, we've reduced our emissions? And I think that's an interesting question. I would without an amendment to the law, I think it's probably unlikely that, hey, if you use our products, you're better, you're better for the environment. That seems a step removed. But I think it just highlights some of the difficulty in enforcing a law like this with pretty ambiguous statements about what would be triggered if you make statements. We did a panel recently through Dorsey on greenwashing lawsuits and kind of where those are headed, right? And so not only now do you have the threat of consumer greenwashing lawsuits, but now this kind of added layer of potential enforcement. And so I think does that chill companies' desire to reduce their carbon impact? And is California sort of, I don't know, stepping on its own toe and trying to push for climate policy for GHG reduction by implementing something like this that is maybe going to make companies not want to have these goals?
Yeah, it's interesting. If you make no claims about the goals, then you're not at risk, at least for the 1303. I'm sorry, 1305.
Right.
So yeah, it's an interesting challenge as well. I see one person's already asked for information on the greenwashing presentation, so maybe Lori can post a link to that. So
Yeah.
in any event, Kayla, thank you for putting together a great summary slide too, and I just commend this to participants. It's a great single place to look at to see, generally speaking, and again at a very high level, what are the three statutes that we're talking about here and the key elements. Again, I really appreciated the who, the what, who, when, and what happens if we don't do it properly way of approaching it. It's quite helpful to companies for sure. Any comments on this slide, Kayla?
I think this is just a high level recap of everything we've discussed. If you're getting confused by, wait, was this 500 million, 1 billion, too many annual, biannual, it's a lot to keep track of. So it's just easy to do a very quick check, but there's a lot of details to analyze with respect to any individual company's situation.
Yeah, it's just fascinating to think about it. As we do think about that, I we have a couple of kind of takeaways for participants. And Megan, can you talk about the first one?
Yeah, so I think with, the obvious one is not knowing exactly what it means to do business in California. So that reach can be broad and maybe will be narrowed, but we don't know for sure. And then on the indirect reach, this is something we talked about when the SEC proposed its rules as well. Even a company that this doesn't apply to, doesn't meet the financial thresholds, may be asked for the compilation of their GHG emissions. And not all companies are tracking that. They don't have to. There's not always a requirement from air permits or otherwise. And so this could have an indirect reach where companies that are required to disclose all of their scope 3 emissions may be reaching out. And so companies should be prepared to deliver some response to these companies or potentially lose out on market share, right? If a company has a supplier that isn't willing to give them the information they need to comply, they might look elsewhere, right, for that supply chain.
Which is kind of the second, data point. And can you talk about kind of within companies, who are the types of titles or positions of people that are paying attention to this, gathering information? You mentioned a couple already: the finance team, CFO. Definitely. I think clearly marketing and branding is an important component. I would include the sales team, because if you have salespeople who are sending emails, that make certain claims or references, and that would be deemed, selling into or making the claim, so they need to be informed. Others?
It'll also be the environmental health safety teams, right? They're going to be the ones that are compiling the information on the greenhouse gas emissions. They'll understand, where those emissions are coming from, how to track it. Most of these companies, to the extent they are larger, will have, either a PSD federal air permit or a state level air permit that they'll have to track this information, even if it's not regulated, if it's not, they don't have to reduce it. So that those teams, those on the ground technical teams, will need to be involved as well.
Terrific. Kayla, now knowing that you had worked in the regulatory agency world as well, can you talk about the third bullet point and opportunities for companies to express their views on this?
Yeah, so the first law, SB 253, the greenhouse gas emissions one, that has the biggest opportunity for regulatory input, because CARB is supposed to make regulations sometime this year, by the beginning of next year, on the substance of the law as well as the penalties. And so you can look on CARB's website or get in touch with us to get involved in that. And the SB 261 will also have some regulations that really just focus on the penalties. But so there's opportunity to comment as those develop, and hopefully get your questions and concerns addressed.
And then, saving probably the most important takeaway for last. But I was really astounded as we were preparing at the deadlines that are happening, just literally, like, you've already lost 2 weeks of data gathering. And what are you going to do? Let's assume that it is January of 2025, for example, that would be one of the earlier disclosure requirements, but you have to have had your act together as of January 1 of this year in order to comply. So any practical tips on how to deal with this?
Yeah, I think it's just you need, as you mentioned, you need a whole team of people working on this, and getting started right away. I think it's going to probably take a combination of internal folks, as well as potentially technical experts and potentially outside counsel. I don't think that any one individual within a company is probably going to have all of the information that's required for all of these laws. If you've just got your accountant, or just got your lawyer, or just have your marketing person, working all alone, it's going to be really tough to comply.
Megan, any final comments from you?
No, I think Kayla hit it, and let us know if we can help.
Awesome. Well, we had reserved a minute for questions, but frankly, you participants were just extraordinary in the chat pane. So we've addressed most, possibly not all, but most of the questions that were asked in the chat pane. And thank you for being so active and participating and for listening in on this program. And we have, you'll be receiving information on upcoming webinars. Lori has already listed the greenwashing seminar and put a link into the chat pane. So make sure and harvest that before you log off. And also she's put in information on the CLE and a link to that as well. So if you have any additional questions, I highly commend to you our two panelists here today, Megan and Kayla. Their information and bio is in the materials that you were sent. And I can say from personal experience working with the team on multiple transactions and other issues, just how grateful I personally am to the very practical and solid regulatory advice that you give. So thank you, and thank you for the presentation, and thusly concludes our program.
Thanks, Mike.
Thank you.